All right, we're ready to go.
Good evening, everyone. My name is Yadira Jimenez, a community resident in the Hell's Kitchen neighborhood, and I will be your host for this evening. Welcome to the Tenant Know Your Rights training hosted by New York City Councilman Eric Bottcher, Housing Conservation Coordinators, and Manhattan Community Board 4. I'd like to start off by introducing a personal favorite of mine, Eric Bottcher, also known as The Real Deal. He represents City Council District 3, which includes Greenwich Village, Chelsea, Hell's Kitchen, Flatiron, Hudson Square, Times Square, the Theater District, the Garment District, and Columbus Circle. Eric, I hand it over to you, my friend.
Yadira, thank you so much. You're a favorite of mine, and I want to thank you for everything that you've done for your neighbors, for the community, and so much that you're going to do. Resident tenant leaders like you and Alex and so many others are such important partners to us, letting us know of issues in your buildings and helping to organize in your buildings. Happy we've been able to get some wins in your building, but I know we have a long way to go, and we're gonna continue fighting and pushing for you and your neighbors, and Alex and your neighbors, and so many other buildings. We are entering we're in the midst of a very difficult time for tenants in New York right now. And the biggest force at play right now is the extreme upswing in rents, in real estate prices. And I don't think I've ever seen anything like it in my time in New York. When you look at the figures, they're really eye-popping, coming from where we were a year ago, a year and a half ago, when rents went way down, so far down. We're hearing now from lots of folks who signed leases at the bottom of the market and are now being presented with rent bills doubling their rent. I mean, just really outrageous stuff. One of the reasons why I support good cause eviction legislation in Albany. But we have great advocates in our community, like housing conservation coordinators. I want to thank Sherry and Leah and everyone at HCC for your advocacy and for everything that you do to help tenants. I want to thank you, Jesse, and folks at MCB4 for everything you do and for having this forum, because we may need to make sure that residents have the information. The information and the knowledge is key. So folks know what their rights are, know where to go, know what their recourses are. So that's why this forum is so important. I really want to thank everyone here. I want to invite folks to also contact our office. Any tenant in the community who needs help, contact our office. We'll connect you with HCC. We'll connect you with Housing Department of Housing and Preservation and Development. And that's why we're here, to help. We want to make sure everyone stays in their homes. Nothing more important than that during this very difficult time. So greetings from ice cold Worldwide Plaza. Thanks again for everyone, to everyone who's part of this.
Thank you, Eric. Stay warm.
You got it.
Okay, everyone, please allow me to introduce Shari Mandel. Shari is Senior Supervising Attorney at Housing Conservation Coordinators. Shari has been working with and representing low-income tenants for over 13 years. Tonight, she will be speaking to you about updates to tenant rights after the ending of the eviction moratorium, as well as some general information regarding non-payment cases and seeking repairs. Shari, the floor is yours.
Sherry, can I just jump in one quick second?
Of
Just to make
course.
sure the folks who are here from the public, if you do have a question, you can make sure you can just put it into the Q&A function, which is at the bottom of your screen now. And once we get to Q&A, we'll be able to answer it. And it'll also help the folks that are panelists here to better answer your question if you do it now as well. So I just want to make that recommendation. Obviously, at the end, you will always take hands as well, live questions, but I just wanted to recommend that.
All righty, let me just open up my PowerPoint. All right. And I apologize in advance. I have a little bit of a cold, so if I cough or croak, don't hold it against me. So the first thing is, updates for the pandemic. That's obviously, first and foremost in so many people's minds because we are still in the midst of the pandemic to some extent, and people are, of course, still suffering the effects of what has happened the past couple of years, both physically and financially. So as many of you probably know, the eviction moratorium officially ended as of January 15th, 2022. Prior to that, it was there, it stopped, it came back, it was extended, but its official final end was January 15th, 2022. Prior to that date, a tenant could file what was called a hardship declaration, which would say that they experienced either financial hardship or are at high risk for COVID-19 and severe illness if they had to leave their apartment. This hardship declaration would stay the case, meaning it would pause it until the eviction moratorium ended. Now that it has ended, all cases that were stayed due to the filing of the hardship declaration will be scheduled for a court appearance by the housing court unless there are any other types of stays in place for that specific case. The most common stay that would be in place to continue pausing a case would be an application to the Emergency Rental Assistance Program. The Emergency Rental Assistance Program, ERAP, is funded federally and administered by the state. You can apply for ERAP if you had difficulty in paying rent due to the pandemic. And I have the website there to apply, but also if you just Google like NY ERAP, it should be the first thing that comes up. And there also is a very detailed fact section on the website, which has been very helpful since obviously this is a new program, not only for tenants, but for advocates. If you apply for ERAP, make sure to notify your landlord, and if there's a court case, also the judge in the case, that you file the application, and you need to give your application number and your date of birth. There's a couple of reasons for that. The first is that this way they can verify that an application was actually submitted. And also the landlord has to complete a number of things for ERAP to be approved. And they need the application number and your date of birth in order to find your application to link things together. If you're approved, ERAP may pay up to 12 months of rental arrears for rent that became due after March 13th, 2020, as well as up to 3 months of additional rental assistance for future rent. Now, the wrinkle here is that ERAP has announced that applications submitted after September 21st, 2021 are unlikely to receive funds. That's just because, it's federal funding, every state got money, and so many people applied because there was such a need. Obviously, advocates are trying to get more money. And as time goes on and decisions are made on pending applications, more money might be released. There is still a benefit to apply. If you have a housing court case, the case is automatically stayed for the Office of Temporary and Disability Assistance, OTDA, to make a determination on your application. So that means you can apply today, and whether or not you will eventually get money, whether or not they are, have messages posted on the website saying you're unlikely to get money, your case is stayed. There is also, of course, the small chance that, you put in an application and maybe more funds will be allocated. There will be more money released. And so there is a possibility that you can get more money. As for court appearances, if your case was stayed due to a hardship declaration or otherwise hadn't been scheduled by the court, you may receive a notice from housing court or papers from your landlord's attorney saying you have a case in Part Z, Part HMP, or Part A. These parts are essentially intake parts. Part A is for brand new cases. Part Z and Part HMP have changed definitions a little bit over time, but in generally speaking, the HMP part is for a case with a motion, and Part Z is just for a case that's just being calendared. The goal of these appearances, however, in Part Z, HMP, or Part A is just to connect a tenant who's eligible for free legal representation under the right to counsel with an attorney. There won't be anything substantive that's happening on the case, except perhaps if your landlord's attorney shows up and says that they want to discontinue and meaning end the case against you. That might happen. But nothing else will happen on that date. As of today, as of this moment, these appearances are all being conducted virtually. That can change at any point. We kind of, are always on the lookout for new instructions from the court as to how things are being handled. And that brings me to my next slide about if you will have to attend court in person. Unfortunately, there's no hard and fast answer to this. Things are constantly changing, and to a certain extent, it's up to the individual judge. But as of March 28th, meaning Monday, more cases are being scheduled in person. I think right now, most cases are still proceeding virtually via Microsoft Teams. And that could be either with a video call, just like Zoom, or with a dial-in phone number where you would just appear over the phone. But again, things are changing. Trials will likely proceed in person. The newly filed cases, the default is that the first appearance after the intake part will be in person. However, if the parties ask the court to appear virtually, a lot of judges are still granting that request. All cases for repairs, these are cases brought by tenants called HP actions, will be in person unless the tenant has an attorney. And you should be getting information from the court as to when your court date is, if you need to go in person, and where you need to go, whether it's in person to a physical courtroom or to a link or a phone number. If you don't get this information, or if you have questions, then you should just call the clerk's office and ask them. The phone number is here, 646-386-5500. It's always better to ask if you're unsure. If you have a case that started pre-pandemic, so prior to March 13th, 2020, where you had a judgment against you, the landlord must serve and file a motion with the court before they can move forward to try and execute that judgment, meaning before they can try and evict you. So even if you had a case, from 2018, 2019, your landlord still has to file this motion. So it gives you kind of that extra layer of protection. If there was a case against you that started pre-pandemic where you never filed an answer or otherwise appeared, the landlord must serve and file a motion with the court in order to obtain what's called the default judgment. This is a judgment you get when someone doesn't appear in court or doesn't file an answer. So there is, again, those extra layers of protection. Never ignore anything you get from your landlord or the housing court, even if you think the rent was paid or the case is over. If you get something, show up either in person or on the phone or Teams, whatever, because the last thing you want is for the landlord to win because you ignored the piece of paper. It's better to show up and be told you're not needed than to not show up at all. So obviously, ERAP is great. A year, 12 months plus 3 months, so 15 months total of rent arrears is wonderful. But for a lot of people, unfortunately, that's not enough. So the question then is, where else can people go, or where can people go now who likely won't get funding through ERAP? There's still the HRA rental arrears grant, more commonly known as a one-shot deal. The primary eligibility requirements is that a tenant can pay their rent going forward. It's called future ability to pay. And also that they have the right to stay in the apartment, because HRA wants to make sure that the money is being used to keep someone in place. You can apply at the job center or also on the Access HRA portal. There's also city FEPs or FEPs, depending on the circumstances of your household. That's a program where there's essentially a supplement to the public assistance shelter allowance that goes to your landlord. And there's also a number of private charities, Catholic Charities, Home-Based Coalition for the Homeless, that will give small rental arrears grants depending on the circumstances. And they all have their own eligibility requirements. And just a few common COVID-19 questions that we still see. Can you break your lease? Yes, you can break your lease. Your landlord does have an obligation to try and relet the apartment. That's called the duty to mitigate. So they have an obligation to try and relet it. But if they're not able to, or they're not able to relet it at the same rent, if it's a lower rent, then they can hold you responsible for what the balance of your lease term. So if you have 6 months left on your lease, they can sue you in civil court for that 6 months of rent, or whatever the difference is between what your lease rent is and what they rented it for. If you're going to break your lease, it's always best to get something in writing from your landlord, clearly saying they are releasing you from any liability under your lease. A lot of people, of course, during the pandemic left the city and now, are worried that they can be evicted for non-primary residents if they have a rent-regulated apartment. So the short answer here is maybe. This is obviously a very new issue that attorneys and advocates are dealing with, because luckily we haven't had this type of pandemic in the past. There are excusable absences from rent-regulated units. So if you could show that you had to leave because you're at particularly high risk of substantial illness, if you were to catch COVID-19, then I think you have a pretty good argument that it's an excused absence, provided that everything that you maintained your connection to the apartment, that you didn't suddenly file taxes elsewhere and things like that. I think that would start making it a little more challenging. And then, of course, what if I can't pay my rent? So that, ERAP, HRA one-shot deal, and that kind of segues into my next slide, which is talking about non-payment cases. So a non-payment case is exactly what it sounds like. It's a case where the landlord sues the tenant for back rent that they owe, or that the landlord alleges they owe. The landlord, in these cases, the landlord is asking the court to order you to pay. And if you don't pay, they may be able to evict you. But you can dispute the claim in court and present whatever evidence you might have. How do they start a case? They first have to make a demand for the rent in writing. It has to, specifically say how much you owe, the months that are alleged, things like that. Then after that time, the timing ends, they can file a notice of petition and petition to start the case in court. Those are the court papers. In civil court, in regular civil court, it's called a summons and complaint. In housing court, the equivalent is notice of petition and petition. These papers have to be served on you as required by the law. And the court will also mail a postcard letting you know that a case was filed. So if your landlord doesn't serve you properly and you never end up getting it, you should still be getting a postcard from the court. So at least you have that kind of fail-safe. That doesn't mean that you can't allege improper service as a defense. It just means that you're avoiding a potential default. Once you receive a petition for a non-payment case, you have 10 days to file an answer in housing court. The clerk will fill out your official answer to the petition. You can do this over the phone at this time. Of course, again, things might change. You can always call the clerk's office and ask the process if you have any questions about it. You want to pay attention to what's on the papers when you're filling out your answer, because you want to put in as many defenses as possible. And you want to ask questions of the court, the clerks, to make sure that you're doing everything properly. This is what the answer form looks like if someone files on their own. If someone is representing themselves, doesn't have an attorney, it's called being pro se. So this is what the form looks like. So you can file by going in person to the clerk's office in housing court. That's at 111 Center Street on the second floor. You can call the clerk's office. And again, I have the phone number here. You can also file electronically using NYSEF. NYSEF stands for, I think, New York State Court Electronic Filing. It's the electronic filing system for that most of the courts use. It took a pandemic for a housing court to get e-filing, but you can also submit it online. And you should check off as many defenses as you think might apply. It's better to be over-inclusive than under-inclusive, certainly. And for non-payment cases, the way you get a court date is by filing the answer. So if you look at the bottom of this answer form, there's this box that has a court date and a time and a part and a room with all of the information for teams. So you'll see there's a link, there's the call-in number, all of these things. So there's, multiple ways to attend your appearance, quote unquote, attend. So you don't have to worry if you don't have, access to, video conferencing equipment. And again, you'll see this is a new case. You'll see it's in Part A. That's to connect the tenant to an attorney. And, as I said, the answers are where you put your defenses. The defense is a reason you don't owe or did not pay some or all of the rent that the landlord is claiming. This list is not dispositive. It's just some common examples of defenses that we use. Improper service, errors in the papers themselves. You tried to pay, your landlord wouldn't take it. You need repairs in your apartment. The landlord owes you money. Violations of the rent stabilization laws, and that can include an overcharge, can include improper deregulation, a failure to provide a proper lease. There's all sorts of things. And the big COVID-related defense is the Tenant Safe Harbor Act. The New York State Legislature created a defense to help tenants who are financially impacted by COVID. Under this defense, the landlord cannot evict you for money owed during the COVID-19 pandemic period. You can still owe this money to the landlord, but it would be a money judgment as opposed to a possessory judgment, meaning that the landlord can still get a judgment against you, garnish your wages, whatever, but cannot use that judgment to evict you, which, obviously still not ideal to have a judgment against you, but if your goal is to stay in your home, it's kind of the best case scenario for some folks. And as far as counterclaims go, a counterclaim is a claim a tenant brings against the landlord. So examples of counterclaims, and again, not dispositive, your landlord has refused to do repairs. Your landlord is harassing you. Your landlord is doing something in violation of the rent stabilization laws. And just like on the prior slide, overcharge, improper deregulation, failure to provide a proper lease. A lot of these things are both defenses to not paying your rent and also counterclaims. So you want to, again, be overly inclusive to make sure that nothing is left out. And just very generally, in terms of how non-payment cases resolve, unless a case is dismissed by a judge, they will either settle or go to trial, usually. If the parties agree on the amount owed, they can enter into a stipulation of settlement. That would usually provide for the amount owed, the date by which the tenant will pay, what will happen if the tenant doesn't pay. And you should always, always, always include conditions to be inspected and repaired as required by law. If there's anything in your apartment that needs to be fixed, even if it's a minor thing, you still have a right to have it fixed. And if you're going to include repairs, you want to include a completion date by when the landlord will make the repairs and what will happen if the landlord doesn't. Because if you don't have a completion date, then the landlord isn't really bound by a deadline. And if you're going to be bound by a deadline, why not bind them as well? If the parties can't agree on a settlement, the case will likely go to trial, at which a judge will hear testimony and look at evidence from each side and make a determination as to how much rent is owed and by when it must be paid. And, that's why it's so important to include whatever you can in your answer. Because if your case does go forward to trial, if it's not in your answer, then you often can't bring it up at trial. Another big thing we hear from people, and this is, pre-pandemic, during the pandemic, post-pandemic, this will be something we hear for the, rest of my career, is how to enforce the right to repairs. A tenant has the right to an apartment in good condition due to the warranty of habitability. If your landlord has failed to make necessary repairs, you can notify your landlord in writing of the conditions. I always tell people, if you're going to send something in writing, if you're going to send a letter, something by mail, keep a copy and send it certified so you have proof. If you're sending it by email, unless it's an email address that that the landlord reads and responds, I would also send a copy by regular mail. You can call 311 and ask for an inspector from Hpd to come out. The inspector will come, look at the issues in the apartment, issue violations, which, puts the landlord on very official, kind of indisputable notice of the issues in the apartment. If your apartment is rent regulated, you can file a request for a rent reduction with DHCR. I wouldn't suggest that be people's only method to try and get repairs, because the DHCR is pretty slow in non-pandemic times. And what that would do, if it's granted, is the DHCR would roll your rent back to the level it was previously. But the problem here is that if what you want is the condition actually to be fixed, there's no real enforcement tool there. The DHCR will just keep your rent lower, which, don't get me wrong, is great, but depending on what your goal is, that's not necessarily the best or only place you should be going. And then the last option is filing an HP action in housing court seeking repairs. And as I mentioned before, this is a case the tenant files against the landlord to seek repairs. As part of an HP action, if there has not been a recent Hpd inspection, one will be ordered. And ultimately, the landlord will be obligated by court order to fix anything for which there's a violation. So that's often kind of the way that has the most teeth to get repairs done. Everything else obviously is good. It's always good to put your landlord on notice and try to work things out outside of the court system. It makes for a more amicable landlord-tenant relationship. But, if your landlord isn't doing the repairs, then you have a right to file an HP action. And how to get legal assistance, how to get help. Because of right to counsel, there's actually a number of different ways that tenants can be connected with an attorney. As I mentioned before, there's the 3 intake parts in housing court itself, where if you have a case in one of those parts, the purpose of that is for you to be connected with an attorney. You can call 311 and ask to be referred for an attorney in a housing court, in a landlord-tenant issue, and they will make a referral. Similarly, Housing Court Answers, which is an organization that provides legal information, also makes referrals. If you're in HCC's catchment area, you can call us to complete an intake. And as I've said a couple times, eligible tenants are entitled to free legal representation as part of right to counsel. So, attorneys can file motions, put forth your defenses, and prevent the evictions. We assist in raising arrears from HRA and charitable organizations and do that advocacy with administrative agencies that's sometimes so critical to having things move quickly enough. Attorneys also work with organizers to address building-wide issues, and also knowing that there are attorneys available to tenants makes tenants more able to and more empowered to take steps that might cause their landlord to take some sort of adverse action against them. And it really empowers tenants to work with organizers. And with that is my segue to the next section of our presentation. But please put any questions you have in the Q&A.
Thank you so much, Shari. Now, I'd like to introduce Leah James, Director of Organizing at Housing Conservation Coordinators. Leah has been organizing for 20 years around housing, commercial tenants, and economic development citywide. Along with her, she has Alex Young, a 421A tenant leader in Hell's Kitchen. The floor is yours, Leah.
Thank you, Yadira. And thank you for the information, Sherry. So what I'm gonna do, let me do this first. And share my screen. I'm not good with this, always have somebody do it. Oh. And keeping your affordable housing affordable, right? And this evening we'll be talking about your rights for tenants around 421A and LIHTC and inclusionary housing units, which is very heavy in the Hell's Kitchen and Chelsea area. It's also citywide. Just an introduction to HCC and the Affordable Housing Campaign. Housing Conservation Coordinators is a neighborhood nonprofit serving on Manhattan's West Side, Manhattan's West Side, and we work with tenants throughout the neighborhood to ensure safe and affordable housing. For years, we've been working with tenant leaders in 421A and LIHTC and inclusionary units and seeing the same issues arise time and time again, especially around harassment. My colleague Sherry also talked about eviction. It's a range of issues. And now we're working with tenant leaders in these buildings and also creating policy solutions that will allow us to maintain affordability housing going forward. And just to give a brief overview, in New York, there are several distinct programs that are often layered on top of each other. Developers are offered different kinds of tax abatements and zoning bonuses to include small amount of affordable units in their buildings. Some buildings have been, built in the early 1900s, or now you probably see a lot of new buildings coming up in New York City. And these programs are often confusing. In order for tenants to understand their power in these buildings or in their rights, we have to understand those rights. So this evening, we're going to break down and some of these programs. So just a brief history of 421A. There was a concern in the 1970s that residential housing construction was declining as people moved from New York City to the suburbs. In response to this trend, the state passed the original 421A tax exemption program in 1971, with the goal of encouraging the construction of more residential housing in the city. There have been many iterations of this program over the years, which means, which means, I'm trying to use this grid, sorry. Which means, So there have been many iterations of this program over the years, which means that 421A may vary based on when the building was built. This program allows developers and landlords to pay little or no property taxes for the duration of the tax abatement period. There's a lot of misinformation about this program and when it expires. 421A today. 421A, so since 1991, the city has spent $19 billion on 421A while producing a very small number of affordable units. In fact, in some parts of the city, there is no affordability requirement. Additionally, tenants in affordable units often experience discrimination, harassment, and misinformation from their landlords. This year, 421A is up for renewal. As organizers, such as myself and a lot of advocacy and organizers across the city, and tenant leaders. And tenant leaders are, residents that just curious to know how long their apartments will be affordable, and they want to save they and keep their home. And want to see reforms and made to protect tenants in affordable housing units, as well as to eliminate the program altogether. And I know folks probably heard these terms, but this all is combined with each other. And so, of course, we have rent stabilization. And rent stabilization means that rent can only increase by the percentage set by the Rent Guidelines Board. And it also means that tenants cannot have the terms of their lease change, that they are guaranteed lease renewals, and that they cannot be evicted except on grounds allowed by the law. I am also a rent stabilized tenant. Rent stabilization and 421A. All units in 421A buildings are rent stabilized for the duration of the period in which they receive the tax benefit, including market rate units. This the trade-off they make to receive the benefit. Once the tax benefit expires, market rate higher rent units can be taken out of the rent stabilization if the landlord has provided tenants with the proper lease riders with every renewal lease. So there is a difference. You got rent stabilization, and then you have rent stabilization and 421A. Whether or not tenants in affordable units remain stabilized is dependent on the year that the building was built. With other programs the building is subject to and your regulatory agreement, many tenants receive misinformation about this. And that's the confusion. Am I a rent stabilized tenant? How do I find out about my regulatory agreement? And is my rent stabilization building 421A? My building is built 1910. I'm rent stabilized. I have to find out, and where can I find out where my building has 421A? So it's very confusing, and everything is in the language. We do have a link here, which is a fact sheet, but my colleague Alex will get more into how do you find out this information for your building. And then you have low-income housing tax credit. So this is a separate program from 421A called LIHTC. The low-income housing tax credit program, LIHTC, I call it, was first enacted in 1986 and subsidized the equation of construction or rehabilitation for affordable rented housing for low and moderate income tenants. The federal government issues tax credits to state governments. State housing agencies then award the credits to private developers of affordable rental housing projects through competitive process. Most developers use other subsidies like 421A along with LIHTC in order to finance their projects. So how it works. The amount of affordable housing that landlords must provide when they receive LIHTC varies, but it's generally about 20%. Tenants must go through an application or a lottery process in order to qualify. of course, I know folks probably heard of, like places like Housing Connect. The landlord must certify tenants' income every year by requesting a copy of the tenant's federal tax return, W-2 tax form, or third-party proof from tenants, employer, or government agency. Landlord must keep the apartment's low income for at least 30 years. During the first 15 years, the landlord must certify its compliance every year with HCR. The last 15 years is an extended use period and it does not have the same rule. The landlord or the developer must have a regulatory agreement with the New York State Housing Finance Agency, which is part of New York State Homes and Community Renewal, HCR. Some folks wrote DHCR. The regulatory agreements can generally be found online. The landlord cannot retaliate against tenants for complaining about a violation of the regulatory agreement. Landlord must attach the LIHTC lease writer to all leases. And, for folks who's watching, right now, in some cases, that's not happening. Landlords are not doing that as they should. There are no limits on what the landlord can charge for rent in a LIHTC apartment. Buildings subsidized by LIHTC often additionally have 421A tax credits, meaning the rent is already controlled by normal rent stabilization guidelines. Lastly, Inclusionary Housing is a New York City program that allows developers to build in certain areas or build bigger if agreed to provide some affordable or inclusionary units. The most common form of inclusionary housing in our area, Manhattan's West Side, is called the R10 Zoning Bonus, which is where developers are allowed to build bigger buildings as a result of providing inclusionary housing. These units are permanently affordable and don't expire. So you might see some really, really new buildings and might have 20 that's affordable and the rest is not, or some, I've seen that a lot has happened, but they don't feel like they would be affordable and they won't expire. Developers are sometimes allowed to build these inclusionary units off-site, but in the same area, creating inequitable housing. This means your landlord wouldn't be allowed to have a giant building without your unit. I'm going to pass it off. I know that's a lot. So we talked about 3 different programs, 421A, LIHTC, and inclusionary housing. And this is something, again, that's happening in our community and it's happening citywide. I'm going to pass it off to Alex because with all of this information to know what's going on, you have to find it somewhere. And so I'll pass it off to Alex.
Thanks, Leah. Thanks, everybody. Hope you can hear me. So there are several ways to get the information. It's not just one website. They all have their strengths and they're all laid out differently. But as we mentioned earlier, regulatory agreements between your landlord and the state or city can be found online on a site called ACRIS, which stands for the Automated City Register of Information System. And we actually have a guide that tells you how to use all of these for our websites. A great one that people love is called Who Owns What? And it's created by justfix.nyc. And the other superb one is ANHD's Displacement Alert Portal. Sometimes people call it DAP or DAP. And finally, really good as well, the Furman Center's core database. They're all laid out differently, but we do have a step-by-step. And before the Zoom ends, we'll show you a slide of who to contact if you want to see this guide. On to the next slide, please. So the Affordable Housing Leader Group that Leah mentioned at the beginning meets every 3rd Tuesday of the month. And we've made a lot of progress since late 2020. And it's more than what you see here on this slide. The slide can only fit so much, but we do have good news to share. The Hpd Fact Sheet, which you see here on the right-hand side of your screen, was created in October of 2021. It was actually created throughout many months in 2021, but Hpd finally put it out on the internet for everyone on early October 2021. And the Affordable Housing Leader Group actually pushed them really hard over many months last year, because people were just tired of not knowing where to look. So we do give a shout out to Hpd. I mean, we think that fact sheet could be improved, but it's a good start. And the other win that we would like to bring to your attention is the lease rider bill, which is A641 in the Assembly and S76 in the Senate. It's now being expanded with a rewrite, and it's to add some clarity. So if you think about the rider that's giving everybody a lot of anxiety and a lot of aggravation, the rewrites, well, I should say the additional language of A641 is kind of the opposite of that notorious rider. So we consider that, we're very hopeful that that can be finalized, and then the bill can be signed by Governor Kathy Hochul. And one thing that's not on this slide is something I love, Assembly Bill 8899. It doesn't have a Senate side sponsor at the moment, but it will bring protections in perpetuity to certain types of 421A tenants. And there's much more. Like I said, a slide can only hold so much info, but I have a biased opinion. I think we're all that in a bag of chips. And if you want to learn more, next slide, please. Thank you. If you want to learn more, please come to our Zooms, which is every third Tuesday of the month, in the evening from 6:30 to 7:30. Community boards are welcome as well, organizations. You don't have to be a tenant, you could be a tenant advocate. And what we do, and it varies from month to month, but we listen to ideas from you, which can be forwarded to electeds. HCC is really good at setting up lobby meetings with the electeds. We couldn't do it without them. And when available, special guests are invited to deepen our knowledge of the issues and legislation nuances, and including knowledge about how Albany's inner workings operate, as well as New York. And we will show you a contact information slide before the end of this Zoom, so you know who to contact. And as you saw on the previous slide, we've made some really good progress. On to the next, please. So, if you feel that we've gone too fast, don't worry, because we do have a step-by-step guide. And I want to give a shout out to Natalie Nasulich, who created the guide in her time at HCC. I'm happy to pick up the torch along with others to continue to improve the guide and just expand the work of the Affordable Housing Leader Group. So these 5 websites are part of the guide, and the ones in red are government sites, and the other 3 are created by awesome advocates and researchers and policy analysts, and we just love them. They're all different in terms of their layout and how to navigate, and it's all in the guide. On to the next, please. So we would love to hear from you. Our contact information is all laid out here for you. And if you need intake, well, I'll let Leah talk about the importance of HCC intake. So Leah, I'm gonna turn the floor back to you.
Thank you, Alex. And right now the affordable housing, we have partners, but we, like Alex said, we're working with elected officials to draft policies to preserve and to keep affordable housing in the city. And so right now we are working on state legislation, but also been working with City Comptroller Brad Lander, the comptroller, to review, this 421A issue in our community. And so right now we are working again on state legislation, seeing how those bills will be passed around lease riders and such. But still open to any questions anybody has around this. It's a very complex issue. It's been going on for too long. And again, I'm Leah James, I'm Director of Organizing, and my colleague Sherry Mandel. Also, HCC has intake department, Mondays, Wednesdays, and Friday. Even if you want to just, have issues with your building and you want to see if there's opportunity for HCC to organize or you need legal support, here's our phone number and these are our hours. Please call 212-541-5996 to schedule an appointment. And Alex, information is a video group. He also put Alex with the email and the text if you want to know more information about the campaign and also the next steps of the laws that's going to be passed. And of course, we have the councilmen and the community boards information to be engaged and be involved of what's happening, especially in our community. I'll pass it on to you, Bill. You muted.
Yadira, you're muted.
Oops. Thank you, everyone, for taking the time to present. That was a really great presentation and quite informative, even for someone as involved as me. And thank you to everyone, all of our guests who joined us today. We're going to go ahead and open up the Q&A. I do see some questions already in the chat. Shari, I believe they're directed a little more towards you.
Sure.
But also, if you have a question, feel free to use the raise your hand feature or type it into the Q&A field.
Sure. So the first question in the Q&A is asking if you have an open housing court case from 2019, so pre-pandemic, and you didn't pay off the outstanding balance from the pandemic time, and you have a pending ERAP application that hasn't yet been finalized, are you still able to be evicted based on the original case, or does the ERAP rights protect you regardless? So there's kind of two parts to this. With a pending ERAP application, your case is stayed. And if you have not yet told the court and the landlord attorney your ERAP application number and your date of birth, you should do so ASAP. Once ERAP makes a determination on your case, application and pays it out, so it's not just enough that it's pending approval, it's that the payment actually has to be made to the landlord, then your case can go back to court if there's still money owed either pre-pandemic, pre-March 13th, 2020, or if you owe more than the 15 months that ERAP may cover, which unfortunately for a lot of people is the case. So the short answer, so the answer there, it's a two-part thing, but in most cases, yes, you probably could be evicted based on the case that's in place once it's able to be restored. Now, ERAP does have protections in it that if a landlord accepts ERAP funds, there are certain protections that a tenant cannot be evicted, but it doesn't include for non-payment of rent. However, there are still a lot of options available. Applying for the one-shot deal, talking to private charities, seeing what, if you might be eligible for city FAPs or FAPs, depending on the composition of your household and your, personal situation. So it's not just, hard and fast, well, ERAP didn't pay everything, I lose my apartment. There's plenty of options. And I do encourage anyone in that situation to reach out to get some legal advice on their very specific situation. And the next question, if you're in a building that is rent stabilized and have been making your housing court payments, does that mean that you have to be offered a lease renewal? So the first thing I would say is that it's not actually whether or not you're in a rent stabilized building, it's whether you're in a rent stabilized apartment, because you can be in a building where you are rent stabilized and your next door neighbor isn't. And that could be because of a variety of factors. So it's about what your specific apartment makeup is. But if you're rent stabilized, your landlord is obligated to give you a lease renewal, even if there's a pending court case for non-payment. Even if you haven't been paying anything, they're still obligated to give you the lease renewal. Excuse me. Obviously, at the end of the day, if you don't pay any of the money that's owed, you could be evicted, and that would terminate any lease renewal that they gave by virtue of the eviction. But your landlord is still obligated to give you a renewal lease. If your landlord hasn't, sometimes there's some, confusion as to what the obligations are where there's a pending case. But I would suggest reaching out to your landlord, contacting the DHCR. Obviously, if you have an attorney in a court case, talk to your own attorney, who can often just reach out to the landlord attorney and clear things up. And the important thing is that if the landlord doesn't offer you a lease renewal, they are also not entitled to increase the rent. So that's just something to keep in mind. And then the last question, what type of protection does a tenant in a non-regulated apartment have against extremely large rent increases? So unfortunately, not much. If you're in a private market rate apartment, your landlord can basically increase the rent however much they want. And we've definitely heard situations where market landlords are increasing rents like astronomically right now, which kind of seems so illogical given that so many people moved out of the city and broke their leases and so forth due to the pandemic. But if I could understand and explain what landlords do, I wouldn't have nearly as many clients as I do. But the one protection that is in place is that if the landlord is intending to raise the rent by 5% or more, they have to notify tenants within a certain period of time, depending on how long the tenant has lived in the apartment. If it's less than 1 year, they have to give 30 days notice. If it's between 1 and 2 years, 60 days notice, and more than 2 years, 90 days notice. But ultimately, that's the only protection that's in place. Well, depending on the makeup of your building, if it's more than 6 units, if it's an older building, it might be worth contacting the DHCR for a rent history to see if it is or should be rent stabilized. There's some just investigation that could be done, which obviously would then give you protections from improper and too large rent increases. The other thing to keep in mind, similarly to rent-regulated apartments, if the landlord doesn't send you a renewal, or in a market rate apartment, or sends you a renewal and you don't want to sign it because the rent increase is too high, your landlord is not allowed to increase the rent, even if you stay over the end of your lease. So I think that answered the 3 questions that had been posed in the Q&A. Obviously, if I missed anything or people have any more questions about my answers, feel free to let us know.
Thank you so much, Shari. I can presume that this concludes our presentation unless someone else has any questions, comments, feedback, and anyone else of the fellow presenters have anything else they'd like to say?
I would just say that I think the most important thing is, when in doubt, speak to an attorney. Don't self-evict. Talk to someone to know your options, because a lot of times there are things available to you or for you that you might not know, because this is, because this might be a new thing for you. So really, even if you think that everything is hopeless in your situation, speak to someone. And sometimes the answer is that it might be a little bit hopeless, but it's also better to know what the situation is for sure and have certainty than to, have it be a question mark and not know what's going on.
Can we put the contact information slide to linger as the last thing so people could take a screenshot if they want? Or is that too? I don't think I can share screen here. Jordan, were you going to say something?
While we get that slide up, I'll just say that obviously Community Board 4 has a Housing, Health, and Human Services Committee that meets monthly. We routinely have things come before it that HCC is, working on or being involved in. We routinely review affordable housing applications, and where it's an open and public forum. So it's just another avenue in terms of which, if you need help or information, we can go there as well. And this video or this recording is streaming live on our YouTube channel, and that's what it'll be going forward if anybody wants to go on it later and share it for any reasons. And of course, I think this is already said, but I think any of the information provided on the slides, I think we could probably be disseminated as well. So, and I want to thank HCC for suggesting this idea and then also taking the leadership and running all of it. You guys did a great job.
Thank you. Thank you. And I encourage, you have the right to start a tenant association in your building. You have a right. And if you need help to do that, please reach out to HCC, 777 10th Avenue. And thank you. This is a great opportunity. This will happen again. I know, for sure.
Certainly, and I'll also hop in as we pull up that slide with everyone's contact info. You can always reach out to our office as well. Certainly, happy to help however we can, and we work with HCC constantly, and Community Board 4 certainly. So we're always happy to be reached out to. My information is on the slide. Please shoot me an email. I love getting emails. So thank you all so much. This has been wonderful.
Okay, everyone, have a good night and stay warm.
Take care. Take care, Leah.
Thank you. See you soon, Jesse.
Definitely.